Okay, so today's mini seminar topic is one of the contractual issues. We want to talk about attorney review clause. Why attorney review is in the process of a sales transaction? And what about other states? Do they have attorney review period or attorney review clause? Not all of them. In New Jersey, we have specifically attorney review period and attorney review process. But New York, they do it differently. So what happened in New Jersey? We want to talk about some historical background, why we have attorney review clause and attorney review period. Okay. Well, the conclusion is real estate agent can prepare the contract with some conditions. Okay. In New Jersey Bar Association, basically attorney groups, and New Jersey Association of Realtors, so realtor group, they were fighting each other actually, because before this judgment by court, it was kind of so chaotic situation, I would say, because realtors, real estate licensees, they try to write the contract. And the attorney group saying that is illegal because attorney has to practice law and the attorney has to write the contract, including real estate transaction. Okay, so the court granted a consent judgment conforming an agreement between the parties, providing the real estate brokers would be permitted to fill in the blank spaces in approved standard contract forms. That was conclusion. So whether you are realized or not, at the top of each sales contract or the lease agreement, it must be written as follows. This is a legally binding contract that will become final within 3 business days. During this period, you may choose to consult an attorney who can review and cancel the contract. See section on attorney review for detail. Okay, so this wording has to be at the top of sales contract and lease agreement. Probably you did not see this because you didn't pay close attention to this attorney review clause, and also this kind of clause at the top of the sales contract. But if you try to look at it, yes, there is this clause always at the top of the sales contract. Okay, so, and also lease contract is the same thing. And why the attorney review clause was created? We want to take a look at some historical background. So preparation of the contract, okay, preparation of the contract, writing, construct the contract, including real estate contracts, historically has been considered to be the practice of law, which only attorney may undertake. So as a result, New Jersey State Bar Association, the attorney, they got together and filed the suit seeking to stop real estate licensees from preparing contracts. Okay. I think in New Jersey, the New Jersey State Bar Association got strong, and they filed the suit so that real estate licensees stop writing contracts, stop preparing contracts. So after years of litigation, So there will be fighting between attorney group and the real estate, the broker group. Okay, two sort of main players in New Jersey for the real estate transactions, of course. So the Bar Association and NJAR, as you know, New Jersey Association of Realtors, reached a settlement that created the attorney review clause. So attorney review is a baby born the battle between the Bar Association, which is attorney group, and NJAR, which is a realtor group. Okay, so the purpose of attorney review clause is to permit real estate licensees to prepare a contract for the sale of residential property while providing the buyer and the seller with the 3 business days to consult an attorney about the transaction. Thus, the preparation and signing of the contract will not be delayed because an attorney was not available. See, you can see the situation. Typically, you can see like commercial transaction. Sometimes if attorney doesn't work diligently, it's very difficult to come up with the contract. Usually you have to wait 1 week is easy, 2 weeks, sometimes 3 weeks. The contract has not been done. Even though 2 parties already agreed terms and conditions. Okay, so they made a deal, but still, because attorney has to write the contract, they have to wait depending on the attorney's schedule. But residential transaction, the realtor group got smart. We don't want to have that kind of situation. So let's make a standard contract form, and we want to fill in the blanks spaces, but we will have this attorney review clause. Okay, so let's make a deal first, and let's sign the contract form, which is predetermined standard form, so we can move quickly. Okay, and then we're going to put the attorney review clause during the 3 business days. Well, in reality, sometimes still attorney is getting delay the process because attorney is busy, then they started attorney review, then they didn't complete, they don't complete fast enough sometimes, okay? But I think we made great progress in terms of moving forward quickly, rather than just waiting for attorneys writing the contract from the beginning. Okay, so that was a successful endeavor. So preparation and signing of the contract will not be delayed because an attorney was not available, but the parties have the right to have an attorney review the contract to protect their interest. That's how they started. And that's how this attorney review clause got into this standard contract. So what is then actual attorney review clause? In fact, if you look at the section 35 of New Jersey standard sales contract, you will see this exact wording, attorney review clause. And also section 33 in New Jersey standard lease agreement, you will see exactly same wording. Okay, well, except these 2 things. One is seller and landlord, and the other party is buyer and tenant. But that's only difference, but exactly same wording in sales contract and lease agreement. So what are they? Number 1, it says in the contract says study of attorney. The buyer or the seller may choose to have an attorney study this contract, blah, blah, blah. And this contract will be legally binding at the end of this 3-day period unless an attorney for the buyer or seller reviews and disapproves the contract. So that means if attorney reviews and disapproves the contract which already buyer and seller signed, as you know, okay? That means in order to start a chain review beyond 3 days, they have to disapprove first. That's why you see the first step of the attorney sends to the other attorney says, this contract is approved, therefore I will prepare the rider, or they put the rider immediately, okay? So review this rider, etc. So that's number one item in this section 33 called attorney review clause. Number two, counting the time. You count the 3 days from the date of delivery of the signed contract to the buyer and to the seller. So not the signing date but from the date of delivery, as you know, right? So after you deliver the contract, it will be effective, as you know. So 3 days counting is the same thing. And do not count to Saturdays, Sundays, or legal holidays. The buyer and the seller may agree in writing to extend the 3-day period for attorney review. That's why usually attorney review sends the letter to the other side or email that we're going to extend the 3 days period. So the binding for this 3 days is going to be extended. Number three, notice of disapproval. If an attorney for the buyer or seller reviews and disapproves of this contract, the attorney must notify the brokers. Okay, they have to notify clearly to real estate brokers and the other parties named on the contract within 3 days period. Remember, because this agreement, the attorney review clause, is agreed by attorney group and realtor group. Okay, that's why they put this kind of a notice. Attorney must notify the brokers and other parties. Of course, it could say buyer and seller, but brokers is definitely here. Okay, that's 1 to 3. That is the exact wording for the attorney review clause, section 35 in the sales contract. But take a look at the important note here. To avoid the potential civil liability and the violation of commission rules, you know what to do? You have to do something. Licensees should include all of attorney review languages in all post-contract addenda, which means riders or some addendums for, let's say, price change or anyway, some additional addenda, okay, or revisions that they prepare in sales or lease transactions to which the attorney review requirements apply, regardless of whether the original contract was or was not prepared by a licensee. Well, this means beyond the standard sales contract, sometimes you have to put the addendum, okay? Anything you agree in addition to the standard contract. Sometimes as a licensee, you can just write and you can attach it to the sales contract. But when you do that, you have to put attorney review language, just exactly same 1 to 3. Okay, that's kind of principle. That's rules by commission. You would be safer. If you don't put that and you write some addendum, the conditions, for instance, then you attach to the sales contract, and then you will be potentially liable to civil suit or violation of commission rules. Okay, we have some interesting questions. We understand that now. We understand why attorney review clause is included. And so 2 things you have to remember. Every contract has must have attorney review clause 1 to 3. And also at the top of the contract, they have to have these wordings. And after this seminar, you can check whether this wording is actually located at the top of your contract. Okay, there is. And so we understand that. And it was a big fight between attorney group and the realtor group. Okay, we understand that. So in a sense, is benefit to realtor groups, as I said, so that we can move quicker, okay, without attorneys writing the contract. So already the standard contract is done, and we can just fill in the blank spaces, and then they can sign it. That's it. Okay, in 3 days, it's going to be legally binding. But we have to put the attorney review clause. Okay, and if a buyer chooses to do attorney review, then they can do that. And during 3 days period, they can disapprove the contract and they can extend. Okay, the attorney review period. That's how we usually done. Now, question is, often we have this question. And also buyers and sellers in this seminar also need to know, what about, okay, during the attorney review, the buyer and seller signed, but during the attorney review, the listing agent received another offer. Or during the attorney review, let's say a listing agent receives multiple offers. What's gonna happen? What do we have to do? Well, during attorney review, the written offers are not backup offers. That's real offers. Okay, so must be presented to the owner. The realtors, licensees should know that. And also buyers and sellers should know that too. During attorney review, any written offers come in, then that's not going to be backup offer. That's going to be real offer. So this offer has to be presented to the owner. Okay. So then what? Owner can look at it, and owner can have interest in this offer, and okay, they can switch it over to this new offer. If this new offer is much better than the current one, they can do that. The legal ramification is, because this during the attorney review period, it is not binding yet. So that's why owner can switch over to the offer, the new offer. Okay. But of course, you have to do something. We'll talk about that. Now, after attorney review has been completed, then the written offers came in. That written offers will be treated as backup offers. And licensee must provide the following written notice. If a backup offer comes in, that means after attorney review has been completed, then the licensees notify this way. They notify this fact, okay, backup offer, to the owner to consult an attorney before taking any action concerning the backup offer. Why is that? Because right now you have a pending contract, so you don't want to be dual contract situation. Okay, so you should inform the licensed realtor should notify to owner to consult an attorney. Okay, and also the licensees, the realtors, should notify to the offeror. That means the potential buyer who sent an offer which becomes a backup offer, that the property is the subject of pending contract of sale or lease. That means we have a pending contract. Okay, so you become backup offer. So the realtor should notify them clearly. It says, the rule says is a written notice. Okay. And if the licensee are not licensed with the listing broker, in other words, it's not in-house deal, the copy of a notice to the offeror must be sent to the listing broker when the backup offer is presented. So the other side, the listing broker, has to be informed. Okay, so licensee has to do that. So in a nutshell, during during attorney review, if there is any better offer, then yes, they can switch over. Okay, of course you have to notify, and of course you have to go through attorney. And after you complete the attorney review, if there are better offers, then there will be backup offer. Still, owner has to see these offers. If they want to do something, then they have to consult with attorney. Okay, they cannot switch over, because if you do anything with the backup offer, you might be dual contract, which is illegal. Okay. And typically backup offer means the current deal is not going through well. If they have a trouble, then usually you switch over to backup offer. But that means the current deal is canceled. Okay, so that's why you have to consult with the attorney now. And after the contract is out of attorney review, the licensee still must present all written and signed offers to the sellers or their authorized representatives. You might just throw away after attorney review completed, which means the deal is on the contract, and still offer comes in. What do you have to do? As a realtor, you have to present this offer to, still you have to present to the seller. Okay, seller may not do anything, but still you have to submit this offer to the seller. Okay. 그 어테일 리뷰 클로즈가 이제 들어가 있는데요. 그거는 우리가 이해를 좀 해야 될 것이, 어떤 면에서는 우리 일을 그 에이전트의 일을 더 편하게 하기 위해서, 그리고 더 빨리 진행하기 위해서 그런 그 결론을 내렸다. 어테일 리뷰 클로즈를 넣고 어테일 리뷰를 하게끔 됐다 하는 건데요. 그 전에는 이제 변호사들과 이 부동산 그 브로커들 간에 상당히 텐션이 있었던 것 같아요. 부동산 에이전트들이 컨트랙을 쓰고 진행을 했던 것 같아요. 그러나 상당히 오랜 기간 동안 이제 법정 투쟁을 걸쳐서 결국은 변호사 그룹과 이 부동산 그룹이 이제 법적에서 저지먼트를 받은 거예요. 합의점을 찾아서. 그 합의점이 뭐냐 하면, 스탠다드 컨트랙을 미리 만들어서 사용하고 에이전트들은 블랭크를 채울 수 있도록. 그러니까 원래는 변호사가 아니면 컨트랙을 프리페어하지 못하니까. Okay? 그래서 합의점을 찾아서 그렇게 스탠다드 컨트랙을 만들어서 공란은 에이전트들이 메꿀 수 있게 하되, 단 조건은 이 컨트랙에다가 어터니 리뷰 클로즈를 집어넣는 거를 법적으로 합의를 봤다, 이런 얘기죠. 그 어터니 리뷰 클로즈가 3일 동안에 어터니 리뷰하고 그 다음에 이제 변호사가 만약에 디스어프로브 했다고 하면 이 컨트랙을 뭐 100%, 99.9% 다 디스어프로브 하죠. 디스어프로브 하고 이 3일 기간을 또 연장할 수 있다. 대개는 연장이 되는 거죠. 그리고 이제 그 3일이라는 기간은 비즈니스 데이로 3일을 따진다 하는 거고, 그 다음에 이 컨트랙이 디스어프루브 됐다고 하는 것은, 즉 어토니 리뷰를 시작을 했다라고 하는 것을 반드시 브로커한테 그리고 컨트랙에 있는 모든 다른 파티들에게 노티파이를 해줘야 된다. 그래서 노티스 오브 디스어프루브입니다. 이 세 가지 조건으로 해서 어토니 리뷰를 이제 거기다가 옵션을 집어넣는 거고요. 그런데 이 주의할 점이 뭐냐면 혹시 이제 딜을 진행하다가 무슨 추가 사항을 써넣어야 될 경우가 좀 있죠. 어떤 때. 그래서 이제 부동산 에이전트가 그냥 그 어덴덤 사항을 써서 추가를 시키면 되는 거로 간단히 생각할 수 있지만, 뭐든지 간에 additional contractual issue를 상황을 쓸 때는 컨디션을 쓰거나 이 어덴덤을 쓰거나 라이더를 쓸 때는 반드시 이 어토니 리뷰 클로즈를 거기다가 첨가시켜라 하는 것이 룰이다. 커미션 룰. 만약에 그게 없이 뭐가 진행되고 잘못되면 라이빌리티가 생긴다. C들이 그건 주의해야 되고, 만약에 또 질문이 되게 많이 이제 하는 게 뭐냐면 어토니 리뷰 중간에 오퍼가 들어오면 어떡하는가. 어토니 리뷰 중간에 더 좋은 오퍼가 들어왔다. 그러면 이제 바꿀 수 있죠. 그렇죠? 더 좋은 오퍼로. 왜냐하면 아직 바인딩된 거는 아니기 때문에. 그러나 라이센스 이제 우리 에이전트들이 어토니 리뷰가 끝난 다음에 들어오는 것도 전부 다 프레젠테이션을 해야 되고, 그것은 백업 오퍼가 되는 거죠. 물론 어토니 리뷰 중간에 들어오는 것도 백업 오퍼로 될 수 있죠. 네. 그러나 백업 오퍼로 그러니까 리갈리 취급하지는 않는다. 그거는 그냥 오퍼로 취급해서 주인한테 프레젠테이션 해야 된다. 아무튼 우리 에이전트들은 어토니 리뷰 중간이건 아니면 끝났건 언더 컨트랙 상황이건 모든 오퍼는 자우전 주인한테 프레젠테이션이 돼야 된다. 그것만 알고 있으면 되겠고요. 당연히 백업 오퍼가 들어왔을 때는 정확하게 오너한테, 그 다음에 오퍼를 보낸 측한테, 그 다음에 오퍼를 보낸 이제 브로커 쪽에 리스팅 브로커 쪽에도 반드시 노티파이가 돼야 된다. 그런 내용들이 이제 있고요. 그 다음에 한 가지 여기 탑에 있는 거, 이 지금 굵은 글씨로 되어 있는 것이 이제 아까 그 변호사들이 합의한 거가 이 내용이 계약서 맨 위에 꼭 올라가 있어야 된다. 그래서 컨트랙을 여러분들 보시면 이 내용이 여기 들어가 있다. 그래서 사실은 이제 더 좋게 하기 위한 그런 거였는데, 왜냐하면 커머셜 트랜잭션이나 이런 것들을 보면 변호사들이 이제 컨트랙을 쓰니까, 근데 만약에 변호사들이 일이 너무 많아서 이걸 신경 못 쓴다 그러면은 뭐 계약서 만드는데 한 주도 지나가고 두 주도 지나가고 그러잖아요. 티피컬하게 커머셜은 좀 그런 경향이 있어요. 왜? 스탠다드 컨트랙이 없기 때문에. 그런데 또 우리 부동산 에이전트들이 컨트랙을 쓸 수가 없기 때문에. 그래서 그런 문제를 이 레지덴셜, 특히 이제 리얼터들은 레지덴셜을 주로 다루는 사람들이잖아요. 그러니까 굉장히 스마트하게 이제 법적에서 싸운 게 된 거죠. 그래서 결말을 얻어내서 이 스탠다드 컨트랙을 써서 빨리 진행하고 변호사 기다리지 말고 단 변호사한테 리뷰할 수 있는 그러한 컨디션을 붙여서 하자. 이렇게 지금 된 거죠. Okay, I think that's pretty much it about some legal background with attorney review clause and as a realtor, what we should do during this attorney review and also after attorney review. Okay, I think that's pretty much it. See you all next week.